Hello. Thank you, John, for that wonderful introduction. Thank you, Team Revel. I really appreciate being here. It's an honor to be on stage with such great speakers, and I hope that I can bring an interesting perspective and bring a little bit of perspective on the legal implications of a product that is defective. So who am I? As John pointed out, I am an attorney. I worked at a major international law firm in their product liability group. 95% of my cases were product liability cases, meaning that I litigated defective products. I did consumer products, medical devices, heavy equipment, that kind of thing. I came to Norris McLaughlin and I diversified a little bit of my practice, so I do a little bit more general commercial litigation, corporate work, and I also work in the cannabis space. So, what are the legal implications of a defective product in the vaping space? You have, let's say that you're an operator in a legal cannabis, in a recreational marijuana state like California or Colorado. You are a processor of vape cartridges. You fill them, you distribute them, and they go to retailers throughout the state. You're basically living the dream, right? Well, one day you get a call from an attorney who says, I represent a client who was injured or who died because of your product. What are you facing? Well, it's a product liability claim, and what product liability claims are strict liability. Strict liability means that if the plaintiff can prove that your product was defective when it left your company and it injured somebody, then you're liable for it. So there's generally three types of claims in the product liability context. There's design defect claims, manufacturing defect claims, and failure to warn claims. Design defect claims are generally when you design defects claims are when your product is defectively designed, and in the vaping context, that means that generally you put something in the product that shouldn't be there, and it's harmful to the end user. So we've talked a little bit about vitamin E acetate. If your formula includes vitamin E acetate and that's proven to be the cause of a vaping-related illness, that's a defective design claim. A manufacturing defect claim is if you're filling it and let's say some vitamin E acetate falls into the mixture by accident, you didn't design it that way, but it just happened to get into the end product. Or if a piece of glass shatters and then the end user, pops up and hits them in the face and gets in their eye, that's a manufacturing defect claim. Failure to warn claim is when you should have warned the end consumer about a reasonably foreseeable consequence of using the product. So let's say that 20 years from now, we find out that vaping causes cancer or whatever you put into it. If you know that vaping causes cancer and you don't warn about that risk, then you could possibly be on the hook for a failure to warn claim. So what do you have to protect against? You have to protect against the foreseeable use and the foreseeable misuse of your product. So you don't have to protect against unforeseeable things. So like in this slide up here, you can see a forklift being lifted by another forklift. People are tremendously stupid in so many ways, and you can't prevent everything. You're not omniscient, and you don't have to be. You wouldn't be liable for failing to warn somebody not to do that. If, however, you're a saw manufacturer that has a guard on it that is cumbersome to use, and the machinist has to, it's very difficult for the machinist to do his job with the safety guard on, you may be liable if he decides to take that safety guard off. So in the vaping context, if somebody takes your vape cart and sticks it in their ear and punctures their eardrum, that's an unforeseeable use. You would not be on the hook for that. However, If somebody were to take your product and perhaps refill it with a fluid or put an adulterant in it that shouldn't be there, can you be liable for that? I would argue no, because that's my job. But that might be, I could definitely see a creative plaintiff's lawyer coming up with that argument, and it might have to go to trial. And in that context, you might be spending a lot of money to defend that litigation. And if your end product is defective and somebody dies as a result of it, damages for product liability claims where there's deaths involved can be millions, if not tens of millions of dollars. So the consequences of creating a defective product are very severe. So who can be liable? Let's go back to this example. You're a processor in a state where you're filling vape carts and you're sending them to distributors, and they're being sold throughout the state to retailers. You get your cannabis from Jimmy's Organic Cannabis Farm. Who can be liable if the product is defective and injures somebody? Potentially anybody in that chain. Now we're looking at this from the 30,000-foot level. Each of these people has their own claims and defenses, but theoretically, looking at it from the plaintiff's perspective, he could sue anybody in the chain. So how do you protect yourself? There's a number of ways to do this. The first thing is common sense, good business practices. You want to work with quality business partners who share your goal of making the highest quality, safest product on the market. To recap, don't make a defective product. And how do you do that? You work with quality business partners. You work with people who share your goal of making the highest quality product, who are financially sound, so that if and when the shit hits the fan, you have somebody to go look to. And you want to get indemnification agreements in your distribution agreements. That means that whoever you get your product from will hold you harmless for any liability arising out of their product or their actions. But before you do that, the first step, if you're an entrepreneur in this area, what you want to do is do careful business planning. So if you and your friend want to start a cannabis business, a cannabis retail shop, a dispensary, and you also get approached to do some research for a research partner. The first thing you should do is incorporate your business. Now, this is a pretty simple chart that shows owner A and owner B forming a parent corporation, and then a subsidiary retailer and a subsidiary research lab. Now, what this is designed to do is limit your liability, limit your personal liability, and limit your corporation's liability. So if and when somebody sues you, by the way, there are product liability claims already in this industry. Washington State has one where the plaintiff sustained vaping-related illness to his lungs, and he sued all the retailers, the manufacturer of the vaping cartridge, and the manufacturer of the battery. So the best protection that you can have is to do careful corporate planning. And then you also want to do the obvious. You want to have impeccable design. You want to work with partners who know the industry, who know the manufacturing process, you want to keep up with the market, you want to keep up with your competitors, you want to look to scientific and engineering studies to make sure that your product is in line with the highest and the most state-of-the-art of the industry, and you want to perform safety testing. Safety testing is hugely important. The other thing you want to do is get product liability insurance if you can. You want to get commercial general liability with a product liability insurance. Getting insurance in the cannabis industry is difficult, but it's not impossible. So you want to shop around, and you want to read your policy. You want to read your policy well so that you have all the information that you need and you have the proper protections in place for when you are, so if anything happens, you are protected. So in conclusion, research and think carefully before putting your product to the market. Work with professionals that you trust to minimize your risk and do business with the best business partners. Work with advisors, work with the scientific community, with the engineering community. Make sure that things go well because, as I said before, and you might not have heard me, damages in these cases could be in the millions, if not tens of millions of dollars, and that doesn't include attorney's fees, which are quite expensive anyway. But I wish you all the best of luck, and regardless of what you're doing, whether you're in the space now or you're getting into the space, if you have any questions, feel free to contact me at any time. All the best.